My daughter-in-law walked into my living room 3 weeks after my jewelry collection disappeared, wearing my late wife's emerald pendant around her neck like it was hers to begin with. I noticed it the moment she came through the door. The way that green stone caught the afternoon light, swinging slightly as she moved. I'd watched it do the same thing on Margaret's neck for 31 years. I knew every facet of that pendant. I'd bought it for our 10th anniversary at a small jeweler on King Street in Charleston. The clasp had a tiny dent from the time Margaret dropped it on our bathroom tile, and we both got on our knees to find it. My son didn't notice. He never noticed anything about his wife anymore, or maybe he noticed everything and had simply chosen a side. I didn't say a word. I poured coffee and asked about their drive up from Savannah, and I sat across from them at my kitchen table and smiled and asked about the new house they'd been talking about buying, and inside my chest, something went very cold and very still, the way a pond freezes from the edges in. Let me back up. My name is Leonard Holt. I'm 68 years old. I spent 32 years as an insurance fraud investigator, private firm, then my own consultancy, which meant I spent 3 decades being paid to notice things other people missed, to trace money that didn't belong where it ended up, and to build cases that held up under scrutiny. I retired 4 years ago when Margaret got sick. I spent the last 14 months of her life by her side, and when she passed, I sold our house in Mount Pleasant, South Carolina, and moved to a smaller place in Aiken, about a 2-hour drive inland. Quieter, less everything. That was the idea. Margaret's jewelry collection was the one thing I'd kept out of storage. It wasn't worth a fortune by collector standards, maybe $60,000, $70,000 if you found the right buyers, but most of it had been in her family for 2 generations. Her mother's pearl earrings, a sapphire ring her grandmother brought from Poland, the emerald pendant, a few other pieces we'd collected over the years. I kept them in a wooden box in my bedroom closet, inside a fire safe I'd bolted to the closet wall. Combination only I knew. My son Trent and his wife Camille had been staying with me for 6 weeks. That's the part where most people would say, well, there's your mistake, and maybe they're right. But Trent is my only child. He'd called me in February saying they were between places, that the lease on their Savannah apartment had ended and the house they were buying had a closing delay, that they just needed somewhere for a month or 2. I said yes without thinking much about it. He was my son. His wife seemed fine. A little distant, a little too focused on her phone, but fine. They left on a Thursday morning in March while I was at my doctor's appointment. Packed their car, sent me a text that said, "Thanks, Dad, meant everything to me. Talk soon." No conversation. No goodbye. When I got home, I noticed the closet door in my bedroom was slightly ajar. I always leave it closed. I remember standing in the doorway for a moment, just looking at it, before I made myself walk over and open it. The fire safe was there. The combination lock was still set. When I entered the combination and opened it, the wooden box was gone. I sat on the edge of my bed for a while, maybe 20 minutes. Just sat there. The wooden box held my late wife's jewelry. It held 31 years of our life together in small, tangible form. And now it was in the trunk of my son's car somewhere on I-20 heading south, next to his wife, who was apparently talented enough to crack a combination lock, or had watched me open it at some point and memorized the sequence. Or maybe Trent had told her. I didn't know yet which version was true, but I knew both of them were in the car together, and neither of them had said a word to me. I called the Aiken County Sheriff's Office. A deputy named Cortez came out, took my statement, made notes about the safe and the combination and who had access to the house. He was professional and direct and told me, gently, that without evidence of forced entry, and given that they'd been lawful guests in my home, the case would be complicated. He took photos. He said they'd investigate. 3 weeks later, on that ordinary Sunday afternoon, Camille walked into my kitchen wearing Margaret's emerald pendant. She'd driven up with Trent for a visit. That's what they called it, a visit. I suppose they wanted to see how I was handling things, whether I'd connected the dots, whether the old man had figured it out yet, or maybe Camille was simply careless in the way that people are when they think they've already won. We had lunch. We talked about the weather. I asked again about the house they were buying, and Trent mentioned they put an offer on something in Savannah's Ardsley Park neighborhood. A real estate market I happen to know ran between $400,000 and $600,000 for the kind of house he was describing. 4 bedrooms, detached garage, renovated kitchen. He was an account manager at a logistics company making somewhere around $60,000 a year. Camille did freelance graphic design and cleared maybe $20,000 in a good year. I looked at the pendant around her neck and I said, "That's beautiful jewelry, Camille. Where'd you get it?" She didn't even flinch. "Flea market in Savannah. Isn't it pretty? I have a thing for vintage." After they left, I went to my study, opened my laptop, and created a document I titled simply March. 32 years of fraud investigation. You learn things. One of the things you learn is that emotion makes you sloppy and patience makes you dangerous. I cried enough in the weeks after Margaret died. I wasn't going to cry now. I was going to work. The first thing I did was contact a friend. Retired FBI, now a private investigator in Colombia, named Reese Whitmore. I'd referred him clients over the years. He owed me several favors and was happy to begin collecting on one. I told him what I needed, a financial picture of my son and daughter-in-law over the last 6 months. Where was the money coming from? What had been purchased? How did the numbers add up? While Reese worked, I performed my own performance. I called Trent the Monday after their visit and told him I decided to drop the police report. "I've been thinking about it," I said, "and whoever took Margaret's things is gone, and I don't want to spend the rest of my time I have being bitter about material possessions." I heard the relief in his voice before he rearranged it into sympathy. "That's the right call, Dad. She'd want you to be at peace." I made 2 more calls like that over the following weeks. Chatty, warm, nothing to see here. By the end of the month, Trent had stopped careful talking and started just talking. They were excited about the new house. Camille was thinking about expanding her design business. Everything was coming together. Everything was indeed coming together. Reese called me on a Tuesday in early April. He had a Bluetooth headset he used during these calls, so he could pull up documents while he talked, and I could hear the soft click of his keyboard in the background. "Leonard," he said, "your daughter-in-law is creative. I'll give her that. She'd sold the jewelry piece by piece. Not all at once. That would flag attention. Over 6 weeks, she'd visited 3 different estate jewelry buyers across Savannah and Hilton Head. Pearl earrings here, sapphire ring there, a brooch, a bracelet. She'd kept the emerald pendant, apparently, for herself. The total they'd received, based on what Reese had been able to piece together, was somewhere between $40,000 and $50,000. Estate buyers pay wholesale. She'd taken a loss relative to market value. That money had then moved in a way that was almost elegant in its simplicity. Cash deposits, spread across 3 months, into a joint savings account they'd opened at a credit union rather than their primary bank, then transferred to a down payment on the Ardsley Park house. The mortgage application showed $55,000 down on a $429,000 purchase. Trent's income verified. The down payment sourced as personal savings accumulated over multiple years. Reese also found something I hadn't expected. They'd bought a car, a pearl white Acura MDX financed, purchased in March. The down payment on the car had come from the same pool, $12,000, cash. I sat with all of this for 2 days before I made my next call. A woman named Patricia Elmore ran an estate law and asset recovery practice out of Augusta. I'd worked cases with her firm twice during my consulting years. She was methodical and unsentimental, which were the 2 qualities I needed. I brought my documentation, my timeline, and everything Reese had compiled. She reviewed it across a long conference table while I sat across from her and watched her read. "Criminal route is rocky," she said finally, not looking up. "You've got circumstantial evidence, no eyewitness to the theft, a daughter-in-law who say she bought the pendant somewhere else, and a son who swear up and down he didn't know. Civil court has a lower burden of proof, preponderance of the evidence." She looked up. "You got that." But I'm not here about the lawsuit yet, I said. She put down the documents. Then what are you here about? The house, I said. Tell me about the house. Patricia Elmore smiled for the first time since I'd arrived. Here is what I learned. Georgia, like most states, has a mechanism called a fraudulent transfer claim. If you can demonstrate that assets stolen from you were directly used to purchase property, you can place a lien on that property and, in some circumstances, pursue its forced sale to recover the stolen value. It was not fast. It was not simple. It required documentation that I happened, by extraordinary coincidence of profession and temperament, to have. It also required that I say nothing to either of them for as long as possible. I filed the civil complaint in Chatham County in May. The complaint named both Trent and Camille as defendants. It detailed the theft, the jewelry sales Reese had documented, the down payment, the timeline. Patricia filed a notice of lis pendens on the Ardsley Park property, which meant that anyone doing a title search would immediately see that the property was subject to ongoing litigation. They couldn't sell it, couldn't refinance it, couldn't use it as collateral for anything. They didn't find out for almost 3 weeks. I know the moment they found out, because Trent called me at 7:45 in the morning on a Thursday and said my name in a voice I hadn't heard from him since he was 16 years old and had wrecked my car. Dad. Just that. One syllable like a question and an accusation at the same time. I said, "Good morning." He said, "We got served." I said, "I know." Long silence. Then, "How did you... I thought you dropped the report." "I dropped the police report," I said. "I didn't say I stopped paying attention." He was quiet for a moment, and I could hear Camille in the background, her voice tight and urgent. And then Trent said, "This is going to destroy us." "That pendant," I said, "was on your mother's neck the last Christmas she was alive." The pearl earrings were her mother's. The sapphire ring survived the Second World War in a woman's coat lining. Camille sold them to an estate buyer in Hilton Head for less than half what they were worth. So I need you to help me understand the appropriate level of my concern for your situation. He didn't answer. "Tell Camille," I said, "that I want the pendant back. Whatever else is gone, but I want that back." He hung up. What followed was approximately 8 weeks of what I can only describe as financial siege warfare, which is a genre of conflict I happen to be better at than my son or his wife anticipated. Their attorney, a young man named Joel Baxter, who I suspect was operating significantly outside his depth, sent Patricia a letter arguing that the lis pendens was improperly filed and that my evidence was circumstantial. Patricia responded with 60 pages of documentation and a motion that, in essence, dared Baxter to take us to hearing. He backed off the lis pendens challenge within 10 days. Meanwhile, the fraudulent transfer claim moved forward. In Georgia, you can recover up to the value of the transferred asset, plus attorney's fees, plus interest. My jewelry was gone, mostly sold, scattered across various buyers' inventory. But the law didn't require me to recover the original items. It required me to recover the original items. It required me to recover their value. And the value had gone into that house. Reese, still on retainer, continued monitoring their finances. What he reported was not comfortable reading, though I read it with the clinical detachment of someone reading a case file rather than a chapter of his own life. They had no reserves. The down payment had cleaned them out, and the MDX payment ate nearly $700 a month on top of the $2,400 mortgage. Trent's salary, after taxes, was roughly $3,800 a month. Camille's design income had dried up. Apparently, the lawsuit stress was interfering with her client work, which was a consequence I hadn't planned but didn't mourn. They were spending more than they earned. Every month, the deficit grew. In June, I received a certified letter from Baxter proposing a settlement. They would pay me $28,000 over 5 years in exchange for dropping the lawsuit and the licit pendens. No admission of wrongdoing. I read the letter twice, set it on my desk, and called Patricia. "No," I said. "Didn't think so," she said. "Want me to counter?" "No counter," I said. "I want a trial date." Patricia filed for an expedited hearing. Given the list pendants and the documented financial evidence, the court agreed to a scheduling conference within 60 days. This meant Trent and Camille were looking at sitting in a Chatham County courtroom sometime in the fall, with their bank records subpoenaed and the estate jewelry buyers potentially called as witnesses. Baxter called Patricia directly in July. He was no longer using the formal tone of his letters. "My clients want to discuss resolution," he said. "My client is amenable to resolution," Patricia said, "at his valuation, not theirs." Baxter said, "What's his number?" Patricia said, "The current fair market value of the property, less the outstanding mortgage, as a lien against the house. Alternatively, $62,000 in certified funds, plus the pendant, returned in person." There was a pause on the line. Patricia told me about it afterward, the specific quality of the pause, the sound of someone doing math they don't like. Baxter came back 2 days later. Camille would not return the pendant. They would agree to the lien. I told Patricia the pendant was non-negotiable. 2 more weeks passed. In that time, Reese reported that Trent had taken a cash advance on 2 credit cards totaling $11,000. Camille had listed 3 designer handbags for sale on an online consignment platform. The MDX had been listed for sale on a private platform, though they still owed more on it than they could realistically get. I'd been in Aiken alone for 4 months at that point, in the house I'd moved into when everything was still going to be different. On the mantel in my living room, in the spot where I'd always kept a framed photo of Margaret, I'd placed instead a small wooden box, empty, that I'd bought at a craft store in town. I don't know why, exactly. Something about looking at it when I sat down in the evenings helped me think clearly. My son called me on a Sunday night in late July, without his attorney on the line. I knew it was without the attorney because he said almost immediately, "I have to tell you something, without lawyers." I waited. "I knew," he said, "about the jewelry. I didn't know she was going to do it, but when she came home with the cash, I knew where it came from, and I didn't stop it." His voice was flat, not confessional, more like a man reading a charge against himself aloud. "I told myself we needed it. I told myself you had insurance. I told myself a lot of things that I knew were wrong. Why are you telling me this now?" I asked. "Because she's leaving," he said. "Camille, she's moving out next week. She says the lawsuit is my fault because I never talked you out of pursuing it. She says," he stopped. "It doesn't matter what she says." We were both quiet for a moment. "Dad," he said, "I'm sorry. I don't expect it to count for anything." "It counts," I said. "It doesn't change anything, but it counts." I said, "It doesn't change anything, but it counts." "I know," he said. "I've thought about that conversation many times since." A man calling his father at night to confess a thing he already knew. His father knew, not to change the outcome, but because living with the silence had become its own punishment. I think about Margaret, who would have handled all of this very differently, and I think about who I was before I spent 32 years watching people deceive each other for money, and I wonder sometimes whether I'd lost something along the way or just found out what was always there. But then I think about her pearl earrings in some display case in a shop on Hilton Head Island, and the wondering stops. The case settled in August. Camille, now represented by a separate attorney after splitting from Trent, negotiated through Patricia the settlement terms, a $54,000 lien against the Ardsley Park property, to be paid in full upon sale or refinance of the home, with simple interest accruing at 8% annually until satisfied. Attorney's fees split, and the emerald pendant to be surrendered at a neutral location, Patricia's office. Within 7 days, I was sitting in the lobby of Patricia's office on a Tuesday morning in late August when Camille's attorney walked in carrying a small padded envelope. Camille hadn't come herself. Her attorney handed the envelope to Patricia's paralegal, signed a receipt form, and left without making eye contact with me. I opened the envelope in the car. The pendant was there. The clasp still had the small dent from when Margaret dropped it on the bathroom tile, sometime in 1998, and we both got on our knees searching the floor until I found it near the baseboard, and she laughed that specific laugh she had when something went wrong and turned out fine. I sat in the parking lot for a while. The house in Ardsley Park went up for sale in October. Trent had moved into an apartment. Camille had moved back to her parents' place in Macon. The house sold in December for $450,000. After the mortgage payoff and transaction costs, there was approximately $28,000 in equity, all of which, by court order, went toward satisfying the lien. The remaining balance stayed active, accruing interest, attached to any future assets either of them might accumulate. It wasn't everything. The jewelry her family had carried across an ocean was mostly gone, sold piecemeal to strangers. $40,000 and a year of my life and a relationship with my son that would spend years, if it ever did, rebuilding itself from something I don't quite have a word for. But the pendant was on my mantle now, next to the framed photo of Margaret I'd put back in its place. Justice isn't a feeling. I've heard people say it feels good, feels satisfying, feels like closure. In my experience, and I have more experience with it than most, it feels like the end of a thing that should never have started. It feels like putting something down you've been carrying. I put it down, and I sat in the quiet of my house in Aiken and watched the afternoon light come through the window the way it does in that part of South Carolina in winter, low and golden and without any warmth at all, and I thought that was probably enough for 1 year. The emerald pendant is sitting on my mantle right now, about 4 feet from where I'm writing this. I can see it from here. The clasp still has that small dent from the time Margaret dropped it on the bathroom tile, and I can still picture the two of us on our knees searching the floor for it, her laughing. That laugh she had when something went wrong and then didn't. I think about what it took to get it back. Not the lawsuits, not the filings, I mean the internal part. The decision to stay quiet and work the problem instead of picking up the phone and screaming at my son the day I opened that safe and found it empty. That restraint didn't come from nowhere. It came from 32 years of learning that the truth has better legs than the lie, that patience is not passivity, and that the person who keeps their head while everything is falling apart tends to be the one still standing when the dust clears. What Trent and Camille counted on was that I was just an old man with some sentimental items and no real recourse. That assumption cost them everything they built. And here's the part I keep coming back to. The things they lost weren't taken from them by me. They were forfeited the moment the decision was made in my guest room, or wherever it was made, to treat someone who loved them as a resource to drain rather than a person to honor. That's a choice with a weight to it. It doesn't vanish when the money clears. It travels with you. I'm not a man who believes the universe keeps a ledger, but I do believe, because I've watched it play out across decades of real cases, real people, real consequences, that character compounds the way interest does. Do honest things long enough and the results accumulate. Do dishonest things long enough and eventually the math catches up. Camille and Trent weren't undone by my lawsuit. They were undone by the kind of people they quietly decided to be, and the lawsuit simply gave that decision a deadline. What I want to say to anyone watching this who feels like they're on the losing side of an unfair situation, maybe someone you trusted took something from you, maybe you can't prove it, maybe the people around you are telling you to let it go, is this: clear thinking is a form of courage. It doesn't shout, it doesn't threaten. It sits down at the desk and writes out a timeline and asks the right questions of the right people and waits for the truth to do what it always does eventually, which is surface. I could have confronted them at that lunch table the moment I saw Margaret's pendant around Camille's neck. It would have felt good for about 45 seconds. Instead, I said the pendant was beautiful and asked where she got it, and I filed that lie away with everything else. 32 years of that kind of work will teach you that the most powerful thing you can bring to an unfair fight is not anger. It's the willingness to stay in it longer than the other person expects, with more preparation than they thought you capable of, and the character to do it the right way even when the wrong way would be faster. The pendant is on the mantle. The house in Ardsley Park sold. The lien is still accruing interest on whatever they build next. I sit with that most evenings. It doesn't feel like victory. It feels like something restored to its right place, which is quieter and, I think, more permanent.